In a Florida divorce filed by one spouse, the other spouse has to be formally served before the case can move forward. This video covers who's allowed to do that, what actually gets served, how the process works step by step, and what happens if a spouse can't be located. Florida law is specific about who can serve original process, including a divorce petition and summons. It's either a deputy sheriff, in the county where the spouse lives or works, or a certified private process server, appointed by that county's sheriff after a background check and an examination on service rules. The filing spouse cannot serve the other spouse directly, and no other party to the case can serve them either. This rule exists so service is verifiable and neutral. The person being served has to be personally handed a copy of the summons, Form 12, 910-A, the petition for dissolution of marriage that was filed, and any other papers filed alongside it, such as a UCCJEA affidavit if there are minor children. The process server or deputy then completes a return of service, a sworn record filed with the court confirming when, where, and how the papers were delivered. The process runs in a set order. After filing, the clerk issues a summons for each respondent to be served. The summons and petition are then routed to the sheriff's office in the county where the spouse lives or works, or to a certified private process server, along with any required fee. That person locates and personally delivers the papers, or, under Florida law, delivers them to another resident of the household who is 15 or older if the spouse isn't personally available. The return of service is then filed with the court, and the response clock starts from the date of service, not the date the case was filed. Once served, the respondent generally has 20 days to file a written response with the court. That's true whether the case is expected to be contested or not. Even in a fully agreed case, the respondent still needs to file something, either a full answer or a signed waiver, to formally participate. Florida also has a specific form, the answer, waiver, and request for copy of final judgment, that lets a cooperative respondent who doesn't intend to contest the case streamline what comes after, though formal service still has to happen first either way. If a spouse genuinely can't be located, Florida allows an alternative called constructive service, or service by publication, under Chapter 49 of the Florida statutes. That route is meaningfully more involved than personal service, requires court approval, and comes with real limits. A Florida court generally can't award alimony, child support, or most other financial relief against a spouse who is only constructively served, only dissolve the marriage itself. Virdix prepares the summons and related forms from the answers given, though Virdix doesn't perform service of process itself. Service is arranged through the county sheriff or a certified process server, as Florida law requires. If keeping track of the forms and the process feels like a lot, that's exactly what Virdix is built for. Virdix is a document preparation service, not a law firm, so this is not legal advice, but it can help make sure the paperwork is complete and consistent from the start.